In America, getting a driver's license is a rite of passage. It's a symbol of freedom, a key to the open road. But with that license comes a great deal of personal information, all stored in state databases. For many years, this information was surprisingly easy to get. It was a reality that had dangerous and even tragic consequences. A specific horrifying event in 1989 brought this issue into the national spotlight. An actress, Rebecca Schaeffer, was stalked and murdered by an obsessed fan. The stalker had hired a private investigator who easily obtained her home address from the California Department of Motor Vehicles. This case was a wake-up call for the entire country, revealing a dark vulnerability in our system. The public outcry that followed was immense. People were shocked to learn how exposed their private lives were. Your name, your address, even your photograph were all just a simple request away for almost anyone. Lawmakers knew something had to change to protect citizens from similar fates. The idea was simple, but powerful. The information you provide to get a driver's license should not become a public directory for those with malicious intent. This led to a major legislative effort, a push to create a federal shield that would stand between a driver's personal data and those who might misuse it. It was a turning point in the conversation about privacy in the digital age. This effort culminated in the creation of the Driver's Privacy Protection Act, or DPPA, in 1994. It was a landmark piece of federal legislation. The law's primary goal was clear and direct: to stop state motor vehicle departments from freely giving out the personal information of licensed drivers. It established a new national standard for privacy, a baseline of protection for every person who gets behind the wheel. The DPPA fundamentally changed how government agencies handled the sensitive data they collected. It was a promise to the American people that their privacy would be taken seriously, and that their safety was a national priority. The DPPA was designed to strike a delicate balance. It needed to protect individual privacy without completely shutting down the legitimate and necessary flow of information. Police officers, for instance, need quick access to this data to do their jobs. Insurance companies need it to verify drivers and process claims. The law was carefully crafted to create a system of rules, defining who could see this information, and for what specific reasons. It was not a total lockdown but a carefully controlled system. The era of easy, unrestricted access to drivers' personal details was officially over, replaced by a new framework of protection and accountability. So what exactly does the Driver's Privacy Protection Act keep under lock and key? The law is very specific about the types of information it safeguards. It covers what is known as personal information, which is any data that can directly identify an individual. This includes some of the most sensitive details you provide when you apply for or renew your license. Think about your full name, your home address, and your telephone number. These are the core pieces of information that someone could use to locate you, to contact you, or to harass you. The DPPA makes it illegal for the DMV to disclose these details without a legally valid reason. The protection goes even deeper than just your contact information. The DPPA also shields your photograph or digital image, which is a powerful and unique identifier. It protects your social security number, a critical piece of data that can be used for identity theft. Furthermore, it covers medical or disability information that you might have provided to the DMV. This could include details about needing corrective lenses or having specific medical conditions that affect your ability to drive. This kind of sensitive health information is given the highest level of protection under the law, ensuring it remains confidential and secure from prying eyes. It is important to understand that the DPPA draws a line between personal information and other types of data. The law does not restrict the release of information related to driving violations, accidents, or the status of your license. For example, details about a speeding ticket or a past DUI conviction are generally considered public records and are not protected by the DPPA. This data is seen as relevant to public safety and is often accessible. The focus of the law is squarely on protecting the personal, identifying details that could put your privacy and physical safety at risk, not on hiding your public driving record from view. This distinction is crucial. The DPPA ensures that while your privacy is protected, the system can still maintain transparency and accountability for road safety. It prevents someone from getting your home address just because they have your license plate number, but it doesn't stop law enforcement or a court from accessing records of your driving history. This careful separation allows the law to be effective. It safeguards your personal life while still allowing the systems that keep our roads safe to function as they should, creating a shield for your identity without creating a cloak for unsafe behavior. While the DPPA creates a strong shield, it also includes a set of keys. The law outlines several specific situations, known as permissible uses, where personal information can be legally disclosed. These exceptions are carefully defined to serve important public safety, legal, and business functions. The most prominent exception is for government agencies. This includes all levels of law enforcement, local police, state troopers, and federal agents, who need this information to carry out investigations, identify suspects, and ensure public safety. Courts and other government bodies can also access this data when it is necessary for their official duties. Another major category of permissible use involves matters of motor vehicle and driver safety. This allows for the recall of unsafe vehicles where manufacturers need to contact owners about a potential defect. It also permits insurance companies to access driver information. Insurers use this data to investigate claims, determine liability after an accident, and to underwrite or rate insurance policies. This is considered a legitimate business need directly related to driving. Without this access, the insurance system as we know it would struggle to function efficiently, potentially leading to higher costs and delays for everyone involved. Certain private businesses can also be granted access, but only for very specific purposes. For example, a tow truck company can obtain information to notify the owner of a towed or impounded vehicle. Private toll road operators can use it to bill drivers who fail to pay a toll. Additionally, licensed private investigators and security services can access this data, but only for purposes that are themselves permitted under the DPPA, such as locating a witness in a legal case. These uses are narrowly defined to prevent the kind of misuse that the law was originally created to stop. It is critical to remember that these exceptions are not a free-for-all. Each one is a specific key for a specific lock. An entity that has permissible use for one reason cannot use that access for another unrelated purpose. For instance, an insurance company that gets your information to process a claim cannot then turn around and sell that information to a marketing company. The DPPA establishes clear boundaries and enforces them. The law ensures that even when your information is shared, it is done for a legitimate reason and is not exploited for commercial gain or other unauthorized activities. One of the most powerful tools the DPPA gives you is the right to consent. For any use of your information that falls outside the specific list of exceptions, the law has a very clear rule. The DMV cannot share your data without your express permission. This is what is known as an opt-in system. It means you have to actively say yes before your personal details can be sold or disclosed for purposes like marketing, surveys, or solicitation. The default setting is privacy. Your information stays private unless you make the deliberate choice to share it for these commercial uses. This opt-in requirement is a fundamental pillar of the DPPA. It puts the power directly into your hands. Before this law, your information could be sold to bulk mailing lists or marketing firms without you ever knowing. Now, state DMVs must get your affirmative consent. This is often done through a checkbox on a license application or renewal form. It might ask if you agree to have your information released for marketing purposes. If you leave that box unchecked or check no, your personal data remains protected from those specific disclosures. It is a simple but profound shift, giving you control over your own privacy. Furthermore, the DPPA acts as a federal floor, not a ceiling for privacy protection. This means that individual states are free to enact their own laws that are even stricter. Many states have chosen to do just that, offering their residents an even higher level of security. Some states, for example, have completely banned the release of personal information for marketing, even with a driver's consent. Others might have more stringent requirements for businesses trying to access data. It is always a good idea to check your specific state's laws to understand the full scope of the protections available to you. In the end, the Driver's Privacy Protection Act is more than just a law. It is a vital safeguard in our modern world. It successfully balances the need for privacy with the legitimate needs of law enforcement and commerce. It ensures that the freedom of the open road does not come at the cost of your personal safety. By putting you in control of your data and holding those who access it accountable, the DPPA stands as a critical line of defense. It reminds us all that in an age of information, protecting our privacy is essential for everyone's well-being and security. OSINT Sleuth, a division of Duncan Investigations, conducts driver record searches only for a permissible purpose, always in compliance with the DPPA and relevant state laws.